Hello, I'm Steve Morris. I'm a partner in the Commercial Litigation Department at JMW. In the disputes that I see, it's often the case that there's a misunderstanding or blurring of the lines between directors and shareholders. The directors are appointed by the company to act on its behalf. Shareholders, or members as they're often referred to, own some or all of the company. Through their investment, they have an entitlement to sharing the profits of the company. Duties are typically owed by directors rather than shareholders. Directors' duties arise from a number of sources, so the company's articles, statute. The most obvious example is the Companies Act, the requirement that a director acts in the best interests of the company. There's also common law duties, so duty of confidence, and also fiduciary duty to act in good faith. The articles of association are compulsory. Every company has to have articles, whereas a shareholders agreement is a voluntary document. The articles bind the company, its members, i.e. its shareholders and its directors, and they're a public document. A shareholders agreement is a private document and it only binds the parties to the agreement, typically the shareholders themselves. So shareholders' rights are typically enacted through their ability to vote at shareholders' meetings. A shareholder with over 50% of the shares in a company can pass of itself an ordinary resolution. More serious decisions are made by way of special resolution, which requires over 75% of the shareholders to vote in favour of that. Well, in the case of minority shareholders, the sorts of examples we tend to see is directors acting in breach of their fiduciary duties, actions being taken which benefit a certain class of shareholders over others. In the case of equal shareholdings, the usual classic problem is a deadlock situation whereby each set of 50% shareholders can block an ordinary resolution being passed but can't actively make that decision of themselves, and that creates a deadlock situation. Well, these sorts of disputes highlight why it's so important to have a properly drafted set of articles from the outset, and also ideally a shareholders agreement in place. Minority shareholders can issue a petition to the court if they believe that their minority interest has been unfairly prejudiced. Alternatively, a minority shareholder could issue a set of proceedings called a derivative action, which is where the shareholder effectively seeks the court's permission to step into the shoes of the company and take action, usually against directors who are acting unlawfully or in breach of their fiduciary duties on the part of the company. A last resort is also for an application to be made to court for an order for the winding up of the company.